Hello, and thank you for joining us today as we consider our first top tips of 2026. Slightly different approach to this one. We're taking a look at a specific case that was reported in the media just before Christmas, looking at what happened in that case and looking at what lessons we might be able to learn from that you can apply in your own organisation. So our format today will be as usual. We'll do a short presentation on the topic, and then there'll be opportunity to ask questions. And if you want to ask questions, then please put those into the chat and I'll deal with them at the end. Just briefly, here's our sort of guide for what we'll go through today. We'll be looking at what happened in the case against JD Sports as reported in the media just prior to Christmas. We'll be asking then, arising out of that, what should you do to try to prevent something similar happening in your workplace? And then what should you do if, despite your best efforts to prevent something happening, you do get a complaint of harassment from an employee? How do you respond to that? So let's look at some of the facts of the particular case that we're considering today. Case brought by an individual called Jayla Boyd with the assistance of the Equality Commission for Northern Ireland. For those that don't know, the Equality Commission has a statutory function in Northern Ireland to provide advice and information to individuals and organisations on equality law and preventing discrimination. And it also has some limited funding to provide assistance to individuals who complain of discrimination or harassment in the course of their employment or in accessing services. And in this particular case, this individual sought and received the assistance of the Equality Commission to support her in her case. So what happened in this particular case was that Jayla Boyd was a student studying for her A-levels, and she worked in JD Sports retail store in Belfast part-time while studying to make some money while she was still at school studying. During a shift, unfortunately, she was slapped on the bottom by a male supervisor. She reported the incident to her manager, who checked and told her that CCTV had in fact captured the incident that she complained of. Unfortunately, the supervisor was allowed to continue working alongside Jayla for the rest of the day. When we look in a few minutes' time at some of the lessons that we can learn, one of the first things you should try to do is separate the person who's bringing the allegation from the person who the allegation is brought against. That didn't happen in this case. The two of them had to work alongside each other after this incident. Supervisor, if it was possible to make it worse, probably made it worse by approaching her twice to apologise for what he had done, and his explanation, quite incredibly, was to say that what he had done by smacking her in the bottom was, quote, muscle memory. That was his explanation for what he had done and how he had behaved. Quite incredible, but that's what happened. So following on from that, Ms. Boyd, understandably, brings a complaint of sexual harassment. She made a written statement about her experience, but was not formally interviewed by management in JD Sports about her experience. Probably as a result of no one meeting with her to discuss her experience and what had happened and how she felt unsupported by her employer. She used some annual leave to take some time away from her job because of what had happened and how it had been dealt with. When she came back to work, no return to work meeting was arranged. Nobody arranged to meet her on her first day to sit down with her to see how she was or anything like that. She just took some annual leave and then she went back to work. She was not updated about the investigation or the outcome of her complaint. And these are all the facts as reported by the media, by the Equality Commission press release. So that's where we're getting this from. This is a case where because it was settled, we don't maybe have all of the facts and all of the information about everything the employer did that you might get in a lengthy tribunal judgment. So we're really just working off what was released by the Equality Commission in their press release about what happened. She was further embarrassed then when, during a staff training session, which, by the way, is a good thing, and we'll talk about the importance of doing staff training. But in this particular case, where an individual had been smacked on the bottom by a supervisor, it was it was not advisable to use that as a specific example in a training session where that young lady was actually present. So she had to then sit through an anti-bullying and harassment training session where an example was given of sexual harassment would be if a woman was slapped on the bottom by a supervisor. So in the moment then when she's in that training session, she then feels, well, that's specifically targeted at what happened to me, and that made her feel worse. And ultimately, because of her experience, she resigned from her job. And after that, then she brought a case against the employer with the assistance of the Equality Commission for Northern Ireland. And that case was settled for £65,000. So those are the facts as reported. What we'll look at now for a couple of minutes is just some of the Equality Commission's comments on the case, as well as what JD Sports had to say. And then we'll move on to look at some lessons that we can learn. So the Equality Commission's comments were as follows. They said that employers must have a zero tolerance approach to sexual harassment in the workplace. I think that's not controversial. We should all agree with that. They said employers must have clear policies in place, and managers must be trained. So there's an importance about doing the training for employees, but there's extra training that needs to be done for managers so that managers understand the policies and how to implement them and how to lead a culture that is, has a zero tolerance approach to sexual harassment and knows how to intervene if they see or hear or have anything reported to them that appears to be inappropriate. So it's very important that managers receive training to help them lead in this area. And the Equality Commission have said that complaints must be thoroughly investigated, sensitively, and in a timely manner. So those are the Equality Commission's sort of high-level overview advice for all employers arising out of this particular case. JD Sports then, they made a few comments as follows. They said that the incident was promptly addressed in line with their policies. They said the supervisor no longer works for them. Not clear whether he was dismissed or resigned. Again, that's some of those details that we would have got if the case had gone to tribunal and we had a lengthy judgment. That's just one of the unknowns. We don't know whether he was dismissed or whether he left of his own accord. They did apologise to Jayla Boyd and acknowledged the significant distress caused. So that was their response. So some criticisms of JD Sports then arising out of how they dealt with it. Some things that probably went against them. We'll look in a minute or two around why was the settlement so high. £65,000 is a lot of money. What are some things that maybe went wrong from JD Sports' point of view? Well, I think the first thing on the day that could have been done better was, they let the supervisor continue working with the victim during the shift. There should have been immediate steps taken to separate them, either by allowing her to go home or suspending him or possibly or probably both. But the fact that the two of them completed the shift together that day, and then that opened up the possibility of him making it worse by trying to explain himself and that not going well. Not formally interviewing or supporting the victim was also a problem. They took a statement from her, but nobody met with her. They didn't keep her up to date on how the investigation was going. They didn't do a welfare meeting with her after she came back from her leave or anything like that. And then obviously referencing this very specific example in a staff training session that this victim of this sexual assault was present for also was an error on their part. Some of the unknown factors then that we don't have full detail of, again, as I've said before, was the supervisor dismissed? Don't know. Were their policies clearly communicated to all staff? So JD Sports have said that they dealt with the complaint promptly in line with their policies. We don't know how widely communicated and well trained the staff, the employees were on those policies. It's having the policy is only the starting point. It has to be communicated and employees have to understand it. So had the managers been trained? and had the employees been trained? We know that there was training done after this incident. We don't know what training was done before it. And we don't know, in fairness to the manager who let the two of them work together for the rest of that shift, had they been trained in what to do if someone comes to you during a shift and complains that they've been the victim of sexual harassment or any other form of harassment? Had that manager been given appropriate training by the company to understand what to do in those particular circumstances? We don't know the answers to some of these particular questions in this case. So as we said, £65,000 is a lot of money, very high settlement. Don't know really whether or not the settlement or award would have been any more if it had gone to full tribunal. Would a tribunal have awarded £65,000? I guess we'll never know. The JD Sports obviously felt, or their insurers felt, that it was better to settle for £65,000 than take their chances in an employment tribunal. One of the things that makes this quite remarkable as an amount of an award is that this was a one-off incident. So often whenever we get very high awards for harassment, it's after sort of a campaign of harassment that goes on and someone's subjected to it over a long period of time. As far as we can tell, based on the facts of this case, this was a one-off incident. But I think these are some of the aggravating factors. It was a physical assault, and that's obviously very, very serious. They allowed the two individuals involved to continue working together. There did appear to be a lack of care in the follow-up investigation, and then they used it as an example in training, and that further sort of embarrassed and humiliated the complainant. And those are probably some of the factors behind why they agreed to settle for such a large sum of money in this case. So importantly for us, that's all. It's all a little bit. It's all interesting when it's happening to somebody else and you see it on the news. But actually, we all need to pause and think: is there any reason really why this couldn't happen in any of our organisations? And the answer to that is, well, no. People step out of line. People misbehave. People do things they shouldn't do. And to think that that could never happen to me and in my organisation, it is probably a little bit naive, because where people work together, there's always the potential for people to misbehave in ways that you think maybe they wouldn't, but sometimes people let you down. So what are some lessons from this case in terms of preventing harassment? And we've been over some of this ground before in the not too distant past, but it's worth reiterating in light of this very significant settlement that this company had to pay out just before Christmas. And the first thing to say is that ensure your policies are up to date and clearly communicated. So if you're in GB, you'll know that over the course of the last year or so, we've been reviewing and updating your policies, particularly in line with new requirements to take reasonable steps specifically to prevent sexual harassment. So whenever we review and update policies, which we keep under review from time to time and send them to you, do you then make sure that those are communicated out to your employees? If the policy never makes it beyond, the handbook that sits in your inbox, then it's not really worth having. So it has to be clearly rolled out and communicated to the staff team. Make sure managers know and understand their responsibilities under the procedures to stop banter, if that's even the right word, that might be considered harassment. So managers have to know that they have to step in and deal with things that are inappropriate or might reasonably be considered to be inappropriate in the workplace. And also make sure managers know how to respond to complaints. So, for example, in this case, separate the individuals involved, take steps immediately to protect the person who has brought the complaint. And indeed, at an early stage, if you've no idea whether or not the complaint is true or not, you're trying to take steps to prevent both parties. What if the complaint's false? What if it's malicious? What if it's true? In all of those circumstances, you've got to take steps to separate the parties, to allow some space and time to do a proper investigation. So do managers know what to do if something arises in the workplace, if an allegation is made? And then, as well as training the managers, then are the employees trained? Have you put them through anti-bullying and anti-harassment procedures? Do they understand what is and isn't acceptable in the workplace? And on that, then, have you made use of our training resources that we've made available on our client resources folder? If you're not sure how to access that, get in touch. We'll send you the link. We've got videos for employees to watch. There's an accompanying quiz that then they take to demonstrate their understanding. We did top tips for managers back in November 24, so just over a year ago, where we took managers specifically through their responsibilities under anti-bullying and anti-harassment procedures, what they can do to prevent things from happening, how they nip things, how they should nip things in the bud early when banter gets out of hand, how they should respond to complaints. That's available. There's a little link in the client resources folder where you can view past top tips. There's a little document, you can click on it. So if you find the one that says anti-harassment managers presentation and question and answer session, something of that nature, and click the link, that'll take you to the YouTube link where you can watch that and show it to your managers. From time to time, we go back over these things and make sure that we think they're still up to date and relevant, and where we think that maybe it needs an update or a refresh, we'll let you know if we've updated anything, whether that be policy, whether that be training video. So just do look out for information that we are sending through on this. Make sure that you watch it, that you read it, and that you then think about how you roll it out with your staff team as well. If, despite your best efforts of communicating policies, delivering training, unfortunately, you do still face a complaint of bullying or harassment in the workplace, we would encourage you at an early stage to contact us for advice. We would encourage you to take immediate steps to separate the alleged victim from the alleged perpetrator. Just do that right away, whether that be by way of allowing somebody to go home, suspending, you can do that in the moment, and then that just allows a bit of breathing space for you to take advice and put a procedure in place and set the wheels in motion for an investigation. Really importantly, if you're involved in these sorts of processes, ensure that the victim or the alleged victim feels heard and supported, that they are met with, that time is taken, and that you're meeting them in a private setting and you're giving them space and you're allowing them time and you're showing them that you care and that you're interested and that you want to help them and you want to get to the bottom of what happened and you want to take robust action. Just making them know that, helping them understand that will be a really important part of the process. And then make sure you're dealing with all complaints in line with your policy, not just following the policy in a sort of cold way, but in a sensitive way and in a timely manner without unnecessary delay. These things do usually take a little bit of time to investigate. You've got to meet with people, you've got to maybe meet with them again, you might have to review CCTV footage in this case. It might be WhatsApp messages, emails. You might have to speak to other witnesses, and it can take a little bit of time. But doing it without undue delay, not rushing it, but also not letting it drag out, is really important as well. So those are just a few tips from us for how to maybe stop something like this happening in your workplace and how to respond. And as I said, there's resources available. If you're not sure how to access them, do let us know. So that's us through the presentation. We do want to let you away by 10:30 at the latest. So if there are a few questions, we've got some time for those. So I'll just keep an eye on the chat. I should get a notification if there's anything in the chat. I'll deal with any questions. So now's the time to pop your questions in the chat if you have any. Or it's always okay to not ask a question in this forum, but email us or call us afterwards and we'll have a one-to-one chat with you if you've got any particular questions or concerns arising out of this. So let me just check the chat feature now. There's a question here. Do we assume that the same guidance applies between a manager and volunteers? So in terms of who's protected in law from discrimination and harassment, employees have that protection. Volunteers generally don't. Now, that's not to say, of course, that harassing a volunteer is in any way acceptable. Of course, it's not. If the harasser is a volunteer and the person being harassed is an employee, again, you're probably dealing with that slightly differently than you would be if both parties were employees. But I suppose it's easier with a volunteer. You don't need to worry so much about their rights because they don't have any employment rights. So you can easily take steps to remove a volunteer, stop a volunteer from volunteering if you think that's the appropriate step. But in terms of rights, the employees are the ones with the employment rights and the rights not to be discriminated against or harassed. Volunteers don't have those rights, but of course should be treated with dignity and respect. If they're giving of their time to volunteer in your organisation, then you'd want them to be treated well, of course. Are there any other questions? Here's another one saying, I'd assume this would also apply to volunteers. So hopefully we've dealt with that. If you are coming at this from a charity perspective, I know a number of our clients on the call are charity leaders. We've got charities represented as well as businesses here. If you want to talk in more detail about what any of this means for your relationships with your volunteers, then please let us know, and we'll be happy to discuss that with you further. Question: how long does a victim have to submit a claim? So, in terms of an employment tribunal claim, they would have 3 months from the date of the act that they complained of. There's no particular time limit for raising an internal grievance. So, you would hope, and the encouragement would be, people would raise complaints internally quickly, because that's going to be when recollections are freshest and whenever it's easier to do an investigation in a timely manner if the individual bringing the complaint has brought it to you in a timely manner. But as I said, in terms of them bringing a legal claim to the tribunal, that's 3 months from the date of the act complained of. Now in GB, that's probably going to change over the next little while with the Employment Rights Act coming in. We're going to push out, people are going to be given 6 months to bring most claims. So we'll keep an eye on that over the next while, as we're keeping an eye generally on updates in employment law. But for now, the time limit for bringing a claim would be 3 months from the date of the act that you've complained of. The question here about investigating in a timely manner, which I think I maybe actually dealt with a little bit just in an answer to the at the end of the presentation. Timely, I guess, really means without undue delay. So taking the time required, but making it a priority. So it certainly would have to go towards the top of your to-do list in terms of things that you're dealing with. But I would say that, an investigation of something like what happened in the JD Sports case ought not to have taken very long, really. There was CCTV and the supervisor accepted what he had done. So in terms of investigating it, dealing with it robustly and starting a disciplinary procedure against the supervisor, all of that could and should probably have been, the investigation side of it anyway, should have been wrapped up within a very small number of days, 2 or 3 or 4 days probably, from that complaint being raised to the investigation being concluded. May have taken a little bit more time than that to go through a disciplinary procedure with the supervisor if that was going to be the next step. But in terms of investigating that really shouldn't have taken very long, in my view. Are there any other questions? What would suitable punishment by JD Sports have been? In terms of the individual who, the supervisor who smacked that employee on the bottom, I think it's difficult to see anything other than dismissal being a suitable sanction. I just don't see a scenario where a warning of any kind of final written warning would have been in any way appropriate. So again, we don't know whether he maybe left of his own accord or whether he was dismissed. I don't know, but certainly if it was one of our clients coming to us with that, it would be. I would struggle to understand how you wouldn't dismiss in those circumstances. There's a question here about often one report of harassment can mean others feel they can open up about similar experiences, and that would indeed be true. So how would you deal with multiple accusations? I think you just have to take each one on its own merits and understand that each one bringing it is an individual, that it then deserves care, dignity, respect, and time. So I think you probably, from the perspective of the complainants, you treat them as individuals. Whether or not multiple complaints against the same person about the same type of conduct, maybe that makes it tipping more in favor of going, well, this is more likely to be true because a number of people are coming forward saying similar things. That may be a reasonable conclusion that you draw as a result of your investigations. But if you have multiple people coming forward, I would treat all those as individuals, I think, in most cases. It's coming up on, it's about 10:26, so I want to wrap up in 3 or 4 minutes. Probably time for one or two more questions if there are any, and then I'll say a little bit about next month's top tips. Just give it another 10 or 20 seconds to see if there's any final questions. Yeah, we'll leave it. Question here: should the police be informed? That's a good question. And I don't want to stray into territory that isn't my area. I think if you think there's any sense that there's been a criminal activity, so in this particular case, that's an assault. I don't know whether the police were informed about that. There's an element of if someone's the victim of an assault, they are at liberty themselves to take that to the police. In this case, this young lady was only 17, so there's potentially a safeguarding issue there, whether or not that gave the organization any extra responsibilities. Again, I don't want to stray into area that I'm not an expert in, but certainly if there's any sense that there was any criminal activity, or if it was anything against a child or a vulnerable adult, particularly in a context maybe where you are a charity working with children or vulnerable adults, and there's a safeguarding angle to this, then certainly following your safeguarding policies and reporting that appropriately would, of course, be very important. But we only advise sort of formally on employment law, so I wouldn't want to stray into territory that really isn't our area to give expert advice on. Okay, I think we'll leave it there for this one. Other than to say, please do just familiarize yourself with your policies. Please do familiarize yourself with the resources that we're making available, and come back to us if you've got any queries around those. Much better to get the policies communicated, get the training done for managers and employees before you have an issue, than do what maybe JD Sports did in this case and go, oh, we've had an issue, we better do some training, and then the training is kind of partly based on the issue. It's much better to be proactive and get out in front of something happening rather than reacting to it. So our next top tips is going to be on the 26th of February. And we're always open to ideas about what to do a top tips on. And we had a suggestion that we could do something around recruitment and things to look out for when you're recruiting people. So next top tips in February will be just some things to think about around recruitment. We'll take a look at things like job descriptions, criteria, making sure you're not discriminating in your recruitment practices, and taking any questions that people have around this important area of recruitment. So that's us for today. Thank you for your attendance. If this has been useful and you think you might want to share it with others in your organisation, then when we send the recording round, please do feel free to send it round. Thank you for your time today, and bye, and enjoy the rest of your day. Thank you.